Well, good evening, everyone, and welcome back to AJ102, Introduction to Law Enforcement and Criminal Justice Online. Tonight's lecture is going to be on Chapter 9, which is going to cover issues concerning police conduct. Now, this chapter is going to contain quite a bit of information. Therefore, I'm going to do the best I can to get done within that 60-minute time frame, but it's going to be incumbent upon you to go through your textbook and make sure you also read the chapter to not only add some context to the conversation, as I've stated before, but also to help you by looking at maybe the key terms or the discussion questions that will help you with your quizzes and your exams, etc. So with that being said, let's kind of jump right into Chapter 9. Now, I'm going to skip past the learning objectives because these are things that I want you to read, because when you're done with these chapters, I'd like you to be able to maybe go back and see if you can actually answer some of these or if they were true. So at the end of this chapter, can you explain what police discretion and the continuum on which it exists is? So what is it? So hopefully that kind of makes sense for everybody. So it was 9:30 a.m. on a Sunday morning in North Charleston, South Carolina, when Officer Michael Slager pulled over a Mercedes-Benz for a broken brake light. The driver of the stopped car, Walter Scott, sat at the wheel as the officer came forward and approached, and the squad car's dash cam showed that the two men that were inside the vehicle were talking, and as the officer was returning to his car, Scott got out and ran. Now, regardless of why Scott ran, Slager gave chase. So the officer chased the individual. And what happened next left Scott dead on the ground with multiple gunshot wounds and the officer calling dispatch for help. Now, the officer's account of the incident painted the shooting justifiable. He claimed that when he caught up to Scott, a struggle for his taser occurred and Scott began to overpower the officer. So fearing for his safety, basically it was self-defense. And for several days, this was the only real account of the story until cell phone video showed up. And kind of a side note, we'll talk about body cameras and the importance of those later on. So Slager was after this video showed up, he was arrested and charged with murder. Now, this case added fuel to the national debate regarding race and police tactics and has served to bring heightened attention to the conduct of police. Now, I have a couple of links to this incident if you would like to view it from two different perspectives. It's a really good video to look at. And I'm not going to lean one way or another on this or give you my opinion. I'm going to allow you to look at the video and draw your own conclusion. Now remember, we weren't there, and I'm not defending the officer, and I'm not convicting the officer because I wasn't there. Does it look good? No. Are there some major issues with this case? Absolutely. But I'm going to have you again look at this and kind of make a decision in your mind on what you think about the officer's actions, and then perhaps we can talk about it further at another time. So, police discretion. Now, this word is super important in the realm of policing, more so today than probably ever before. Police discretion has been a theme throughout this text, and just as citizens can decide to obey the law or not, police agencies and their officers can decide which offenses to actively seek and control, and honestly, which ones to simply ignore, and which services to provide, and at what level. Now, police discretion can become an issue of controversy when claims of things like discrimination are added into the picture. Well, how do we define it? Well, police discretion is the freedom of an agency or individual officer to choose to act or not. And whether such discretion is positive or negative is kind of at issue here, or is an issue. Now, this, I believe I posted this link at the introduction portion to the chapter in the module. If I didn't, I would highly suggest that you take the 10 minutes or so to watch this video, because it's an awesome video where a civil rights activist who really isn't thrilled about the way police do their job decides to go through a use of force training program in Arizona. And what's awesome about it is he does have this negative perception of law enforcement, and he thinks that the job is very, very easy. And when he's done with this training, he changes his mind and he readily admits the difficulties that law enforcement have, specifically as it relates to use of force and discretion. I applaud this man for doing exactly what he did and being able to see how hard this job can actually be. And I wish other people could go through that same use of force training that he did. But take a look at that. I just want to say I have the utmost respect for this gentleman for doing what he did and saying what he said at the end of this video. Now, with that being said, again, we kind of already went through this where we know that discretion has been, kind of scattered throughout the text and through a couple of different chapters, and we know that, just as citizens can decide to obey the law or not, police officers and agencies can decide based on discretion, which offenses to seek and control and which ones to basically kind of ignore. And when you talk more about discretion, it might be viewed on a continuum from like high to low. Now, low discretion situations kind of include those things that are routinely done. And here officers don't really have to think about or generally ponder the violation or the action, to be taken. So again, low discretion situations include those involving activities maybe like executing a search warrant or responding to a citizen complaint or seeing an obvious violation of law, for example, a motorist running a red light. So they don't really have to think about it. There's the violation, and they're going to go ahead and maybe issue the citation or not. Now there's a little discretion built in there, but it's kind of a low discretion. Now high discretion situations, in contrast, they're less clear-cut. And for example, a citizen reporting an unknown problem or a fight call next door, the officers have to kind of determine things while they're en route, and then when they get there, like who's the suspect and who's the victim, and is there some type of weapon involved. And the high discretion incidents invite both intentional and unintentional abuses of discretionary power. So hopefully that phrase in itself kind of makes sense. And one of the most important discretionary options police officers have is whether to arrest someone or not. If the decision is to arrest, then you have others that come into play, because now the discretionary power of, say, the prosecutor is going to come into play on whether to actually file the case or prosecute the case. So the ability to use discretion is indeed a vital element of contemporary policing, not to mention the entire criminal justice system. Now, in addition, the wishes of complainants greatly influence police selective enforcement, often more than any other factor. So, when people call in and they're complaining about certain things, or they're wishing us to do certain things, those citizens, they do help us or kind of influence our selective enforcement efforts. So, an example would be someone calling in for drug activity quite often in a certain neighborhood. Well, that's going to kind of influence your law enforcement agency to go out there and maybe handle that particular situation. So police discretion is frequently at the center of issues involving discrimination as well. Racial profiling, and use of force and vehicle pursuits. So you can kind of look at that. Now, discretion, again, remember, it's your ability or your decision to act or not to act, to arrest or not to arrest. And you could see how that could be weaved in, if you will, on issues involving discrimination. You're stopping these folks, but maybe not those folks. Or you're only stopping a particular group of individuals. Or the discretion to use force or not. Or even more so, the discretion to maybe get in a vehicle pursuit, a car chase, or not. So we're gonna talk about a lot of this stuff as we go through, and again, I'm gonna try to stay within that 60-minute time limit if I can. Now, let's look at the difference kind of between discrimination and disparity, and we're gonna define those things as well as we start to move through the chapter. So the guarantee of equal protection under the law to all citizens is a fundamental principle of our democracy. Now, an example question for you. When officers fail to treat citizens equally because of economic status or race or religion or sex or sexual orientation or age bias, is it discrimination or disparity? And I'll kind of sit for just a second and let you sort of kind of decide. Well, I'm going to flip the answer up here so we can kind of get moving on it. So let's define it more. Discrimination is showing a preference in treating individuals or groups, or failing to treat those groups equally, and especially illegal, unequal treatment based on race, religion, sex, sexual orientation, or age. Now, disparity it's kind of a simple difference. It's not necessarily caused by any type of bias, if that kind of makes sense. So disparity refers again to a simple difference, not necessarily caused by any type of violence. So an example, if there are more male drivers and if they frequently break traffic laws more often, the difference in the number of traffic tickets issued to male drivers would be a function of disparity, not necessarily discrimination. Does that make sense? Another example could be in a high school, most students will be between 16 years to 18 years of age. This reflects age disparity, okay, not discrimination. Now, the same issue arises when the number of individuals involved in the criminal justice system are examined. And, are more minorities arrested, processed, and sentenced to prison because of discrimination, or because they commit crimes in disproportionate numbers because of numerous economic or social factors? Now, I'm not going to go into really too much more. I'm just throwing that out to kind of get your brain thinking about the difference there. Okay, and then we have gender issues, which would be differential treatment of men and women, and perhaps even police attitudes towards the LGBTQ community. So disparity and discrimination as related to racial and ethnic minorities has been described as existing along a continuum, if you will, between the extremes of systematic discrimination and pure justice. And we're going to get to a little chart here that kind of illustrates and talk about that. And then there's also issues of class. And I don't mean class in a particular sense of like, hey, he has no class. I mean class as I'm going to kind of define it here. So another area receiving limited attention is discriminatory policing based on perhaps an economic level. Now, more than a half century ago, there was a case that I have here, Griffin versus Illinois, where Justice Hugo Black declared there can be no equal justice where the kind of trial a man gets depends on the amount of money he has. To many people, the O.J. Simpson double murder trial was a blatant example of unlimited financial resources being able to buy a not guilty verdict. And I'm not going to debate the O.J. case with you. I'm just kind of using it again as a reference. But so it's a lack of collected efficacy or producing the desired results, perhaps in poor neighborhoods. And at the law enforcement level, those who are poor are much more likely to perhaps come to the attention of police simply because they are on the streets more. So we have these issues of class that we have to make sure that we are addressing. And I think that kind of makes sense to everybody. And then racial issues. And we're talking about discrimination and disparity. So typically, when people hear the words discrimination, they most commonly place it within the context of race. and it's not always like that, but typically that's what happens. Perceived discrimination is a potential source of crime. And, then you have things like racially disparate arrest rates. And as we've said before, discrimination based on a person's race has in fact come to the forefront of policing in the issue of what we call racial profiling. So let's define that. And again, I'm touching just kind of on the surface of a lot of these things because I'm not going to have time to get to all of them. So what is racial profiling now? We've kind of reached this point where we can actually define it. Well, racial profiling refers to any police-initiated action that relies on race, ethnicity, or national origin rather than on the behavior of the individual for police to believe a particular individual is involved in criminal activity. So hopefully that kind of is an okay definition. Now, the practice of racial profiling is illegal and is typically addressed in department policies that require officers to refrain or not engage in it. Now, there's a group of individuals out there, the Police Executive Research Forum, PERF, that replaces the term racially profiling with racially biased profiling. And the reason they do this is that they state that the word profiling creates confusion about an otherwise legitimate policing term. And I'll kind of go over that in just a second. So racial profiling, we heard that and we introduced that in Chapter 6 in connection with traffic stops, if you can remember. Now, when PERF talks about replacing racial profiling with racially biased profiling, they're doing that again because that word profiling can be a legitimate thing that officers might use. And it's not the only thing, but you can, people that work for airport security or TSA, they are trained to profile certain things. People with no luggage, maybe of a certain descent or nervousness or a combination of all types of factors. So it's not always just one factor, it can be several factors. And same with those that work customs at the borders to deal with drug smugglers. Typically, they will profile individuals. So the word itself, okay, has some legitimacy in law enforcement. Now, not when it's specifically based just on race, okay? I want to make that perfectly clear. And that's why they want to change that term to racially biased. so there's no confusion, because profiling is something that is done in law enforcement under certain circumstances. So how do you avoid excuse me, racial profiling? How do departments do that? Well, they do it a couple of different ways. One would be that they focus on an individual's behavior in their profiling. And many departments are training officers in behavior pattern recognition, a technique that originated actually in Israel and is used to look at how individual behaviors, or how they behave in an airport environment, as a way of determining potential threats. And other departments, as I said, are training all airport employees on suspicious passenger observation techniques to look for passengers who are acting out of the ordinary or displaying certain behavioral or observational cues. Are they wearing a warm coat on a hot day? Are they sweating or nervous when they come to the airport security checkpoint? Do they have, carry-on luggage? Again, so these are actions and behaviors, not just somebody's race. So hopefully I've driven that point home. And then another way to avoid charges of racial profiling would be to focus on intelligence regarding known suspected terrorists, the quantity and quality of which has been changed dramatically since 9/11. Now, intelligence operations are controversial, partly because of concern that in the zeal to prevent terrorism, citizen civil rights might be abridged. And further controversies involved concerned citizens and civil rights groups that fear that law enforcement agencies will gather and keep information about citizens who haven't committed crimes but are exercising their civil rights on controversial issues. So another thing to kind of throw in here would be what they call data collection. And now many departments have turned to data collection in order to track those who are being stopped. However, this can be very, very costly, and the question is, what are the pros and cons? You have to kind of think about that. And the data collection would be where when they stop someone, they record the information of certain characteristics of the individual, and one could be race on a say a traffic ticket or a field interview card, or perhaps even every contact that they make, to look and see later on. They can analyze the data to find out if a particular group is being stopped more than another one. So you can see that it could be costly, but at the end of the day, you might be able to find out some pretty decent information on that. Well, what about immigration issues? So now we're going to kind of go into a very touchy subject, but that's okay. And we're still under the umbrella of discrimination and disparity here. So an estimated 11.3 million illegal immigrants reside in this country and have become an increasing focus of controversy. And the economy, possibly racism, and the 9/11 attack on America carried out by hijackers who entered this country on student or tourist visas contribute to the changing political climate. And Americans recognize the porous borders, if you will, the open borders would be another way to kind of say that, and sometimes perhaps even the lax enforcement as security threats. So we do have to kind of look at the immigration issue. Now, some issues that are related to immigration or challenges that are facing law enforcement agencies in jurisdictions with large immigrant populations include things like those that maybe don't speak English. That's difficult. reluctance to report crimes, perhaps even fear of the police. Maybe people won't call law enforcement because they fear that if they're not here totally legally, that could be an issue. The effects of federal law enforcement actions, things that are going on with federal law enforcement agencies. Confusion about whether and to what extent local police enforce immigration laws. So those individuals may not talk to us because they're confused about, what role local law enforcement plays. And I can tell you, local law enforcement, they are not the immigration police, if you will. Okay, we provide services to everyone, to anyone, and protect and serve everyone. We are driven by the 14th Amendment. So enough of that. What about misunderstandings based on cultural differences? Well, there are going to be some of those perhaps. And personal interactions that damage goodwill and trust. So perhaps some things that have been done in the past that have damaged goodwill and trust, and maybe some of these individuals have been involved in those personal interactions. Well, since we're still on this subject, and we mentioned it a minute ago, let's look at that term profiling for a moment and see if it has some type of legitimacy in law enforcement. Now, a central problem with racial profiling, again, is that it contains the word profiling, which has in the past been a valuable tool in policing for decades, and we've talked about it at airports. Law enforcement and security personnel are taught to watch for certain traits. Okay, and these are actions, so it's not just one little piece, it's a series of things that come together. So like paying cash and no luggage. And the textbook example here uses Middle Eastern descent, but this could be anybody else. Nervousness and so on. To alert them to, let's say, potential terrorists or even drug dealers. And they would do the same thing at the border. So thus, it might be appropriate to change the name of profiling to maybe building a case with race simply a part of most suspects' descriptions. Because truly, when you get a suspect description from someone that's committing a crime, the dispatcher will ask the victim if they call. They'll ask certain characteristics about the person that's committing the crime, and one of those will be what? And I'll let you kind of take a second to answer it. Well, one of those is going to be race, because it's going to help the officer in the field focus their attention on a certain group, but that's part of the description. Is that all making sense to anybody? And I really hope it is. Similarly, because profiling has somewhat of a legitimate place in law enforcement, again, a suggestion is to remove that word entirely and replace the term racial profiling with racially biased profiling, which has, by the way, no place in law enforcement whatsoever. So the courts also, along with that, are generally supportive of race being included as one of, make sure you get this part, several factors used to identify suspects. And one of the cases that is kind of at the forefront would be this United States versus Weaver case in 1992. And I'm not sure if I'm going to have enough time to go through it, so I'm going to skip it, and I'll let you come back and you can look at it. But this case is reference to a DEA officer who stopped and questioned an individual. And again, I'll let you kind of look at the whole thing, but it is a pretty interesting case. So question one, as we kind of keep going here, how can police avoid charges of racial profiling? Well, We kind of already went through that. Now, despite such court support, officers must be educated on how to avoid unintentional racial profiling based on personal bias. And some departments are, or some department measures to circumvent any allegations of racial profiling by omitting race as one of the descriptions used when seeking a criminal suspect. Now, you have to kind of think about that. It's difficult. So think about that sentence and put yourself in law enforcement perspective here. Now, again, despite support by the courts where they're allowing us to use race as a piece, as one component along with others for like a suspect description or something like that, there are some departments that are actually kind of going a little bit further and omitting race as one of the descriptors when used when seeking a criminal suspect. So, for example, the University of Minnesota campus police no longer includes a suspect's race as part of a crime alert, with the administrators there believing that race is kind of too general, if you will, to be used as a descriptive characteristic. Now, we're not going to debate this today, but I think that, well, you decide. Should we do that or not? Should we leave race in as one of the descriptors? So someone commits a robbery, the suspect is 6'1", about 250 pounds, a black jacket, blue jeans, white tennis shoes, and last seen running westbound. Should they be able to add the last piece in there of, it appears the subject is of a certain race? You decide. And now let's kind of move on. Use of force, because this falls under the chapter truly under conduct, or issues concerning police conduct. So, English philosopher Herbert Spencer proclaimed in 1851 that policemen are soldiers who act alone, and soldiers are policemen who act in unison. And as solitary soldiers, the police are justified in using force when required to control crime and keep peace in our society. And that's a pretty profound statement when you're thinking about the fact that it came from someone back in 1851. Now, there are a lot of different thoughts about use of force, and we're going to kind of go through quite a bit of those in just a few minutes. Now, no other enforcement task is more difficult or more demanding personally and professionally than to use force only at the right time, in the right way, and for the right reason. And you have to think about that. That's pretty profound, and it's very, very difficult for an officer to actually do this. So look at that again. At the right time, in the right way, and for the right reason. So extremely difficult. Now, the International Association of Chiefs of Police, or IACP for short, defines force as that amount of effort required by police to compel compliance from an unwilling subject. Because obviously if they were willing, then they would be compliant. So we're talking about unwilling subject. And when most people think of use of force, they typically think of some type of like hands-on or physical activity. However, you should know that an officer's mere presence is in itself considered a use of force. The uniform, the gun, the badge, and everything, you can gain compliance simply by showing up in uniform. So force includes, what does it include? Well, first, what is it? Okay, we gave you the IACP definition. So a shorter one would be action taken to compel an individual to comply with an officer's request. Now, so what is it more, and what does it include? Well, force includes any physical or psychological or verbal contact between police officers and citizens. And think about it. So verbal could be stop. I told you to stop. That's considered in itself using force. And most applications are at a low level and not typically at a high level. Now, it may involve an officer pushing or grabbing or kicking or hitting a citizen. It really might. And force also includes things like police dog bites and control holds and handcuffs and leg restraints and chemical agents like pepper spray or tasers and even firearms pointed in a citizen's direction or the threat to carry out any of these types of activities. And most importantly, studies have shown that 1 to 2% of all police-citizen contacts involve the threat or actual use of physical force by an officer. That's really low. And that in 15 to 20% of all arrests, officers must use physical force to control a resisting person. And although most applications of police use of force are considered kind of low level and do not lead to any substantial injury to officers, suspects, or bystanders, the possibility for force-related injuries does exist, particularly as that level of force tends to increase. So who uses more force? Let's kind of throw this one in here and see how you guys are. Well, what about gender and use of force? Now, research shows that female officers are less likely to use excessive or deadly force. And furthermore, a study conducted by the Los Angeles Police Department found that female officers are often better able than male officers, sorry guys, it is what it is, to de-escalate potentially violent or aggressive situations through their presence and use of interpersonal skills, the way you talk to people, thus reducing the need to employ physical force. And the study was done in 2009. So it's not that long ago, so sorry guys. And then comes this thing that they call use of force continuums. And the amount of force used can be placed on what they call a continuum that runs from something like no physical force, which would be with some cooperative individual, to ordinary force that would be used on a person who is resisting, to that high level or extraordinary use of force, which would be used with somebody who's assaultive. And these use of force continuums, again, are being kind of moved away from, because the perception is that because you have these continuums, that they are kind of linear, kind of like steps, if you will. And the general public basically think that you have to kind of walk through the linear steps. And I think I have a diagram coming up. Okay, I do, good. before you can like advance to a different step, if that makes any sense. Now, critics of force continuums contend that including such tools in an agency's use of force policy is like mixing oil with water. Now, the Fourth Amendment reasonableness clause does not require that officers use the least intrusive means available to them. And a landmark case on use of force, which is Graham versus Connor back in 1989, it's pretty broad, and it favors police officers considering the numerous factors that continuums do not. And in this case, Graham, the court held that the calculation of reasonableness under the Constitution is not capable of precise definition or mechanical application. So the current trend has basically been, again, agencies moving away from the training and use of these kind of continuums, which critics are continuing to argue, again, that the concept is kind of outdated, like call boxes were pretty much outdated. Now, continuums were developed by law enforcement trainers in the 60s. And since then, more than 50 such continuums have been developed. And although many are complex and ambiguous, others have been kind of very, very simple. And some departments use a straight line continuum, and others have adopted kind of a circular continuum to counter criticism that the former option suggests a linear progression, kind of what like I talked about. So here's an example from the Riverside County Sheriff's Department. And it talks about here, and it tells you officers shall not use more force than is reasonably necessary and overcome the resistance of force. And you can see at the bottom here, you have the officer's response on the left and the perception of the officer on the top, and you have command presence and communications, and then control and handcuffing and takedowns and chemical weapons, and we're working our way up. Energy weapons, pepper spray, impact weapons, batons, etc., and then lethal force. And on the left, we move to the right, so we have cooperative, passive, assaultive, and great bodily injury. And as the officer's response or the perception starts to move to the right, the different tactics can be employed. And what I talk about when I said linear before, the general citizen thinks, well, you have to walk through each one of these steps before you can get to the top. Well, what if you encounter somebody with a gun? Should you have to try a control hold first, and then try a takedown, and then use chemical weapons, and then break out a taser when this other person has a firearm? So you can see a lot of times with law enforcement, you may have to go from a consensual encounter to lethal force in about 1 second, depending upon the situation. Here's another look at a reasonable officer response chart, which is really, it's done well. This is from 2010 by the Riverside County Sheriff's Department. And it talks about the factors and this, what they call the objective reasonableness test. Would another officer placed in your situation of similar training and experience believe the level of force that you used was reasonable? And this is how you're going to be judged by the court, actually. And all of the factors are put on this chart to help you or show you. The officer factors are on the left, the suspect factors are in the middle, and the environmental factors are on the right. And I'm not going to spend too much time here, but this is a very cool chart. And take the time to kind of look at it. So as we move on kind of out of the use of force thing, we're still kind of there, but we're going to talk about some other issues related to force. Now, each year people die suddenly while restrained, most of whom were being arrested after some type of violent encounter. And a sudden in-custody death refers to any unintentional death that occurs while a person is in police custody. Now, in 2000, because some of these started to happen, the Death in Custody Reporting Act was passed, which required that data be collected on these types of incidents that are taking place. And some that have happened would be what they call restraint asphyxia, or of course drug abuse and sudden death, or then this last one, which is called excited delirium death. And I'll touch on them very, very quickly. So research shows that a sudden in custody restraint death is a statistically rare event given the annual number of police citizen contacts. And using the Department of Justice statistics, it is estimated that a sudden in custody restraint death has about a 0.000005% likelihood of occurrence. Even so, the tension among science, the use of force, and the law is high in such deaths. Now, some contend that restraint asphyxia, alternately called, or what used to be called, positional asphyxia, results when a person is restrained in a prone position lying face down in a way that interferes with the mechanics of breathing, leading to death. Now, other studies don't support that contention that ventilation is significantly compromised by positional restraints, whether prone or in a different position. Now, factors that are considered to play a more significant role in this type of thing would be drug use, alcohol intoxication, pre-existing heart conditions, mental illness, stress, and of course trauma. And then drug abuse, well, a study analyzed 668 sudden deaths during a 32-month period and found no indication that police tactics or equipment caused the fatalities. Sudden deaths in the general population are often related to cocaine abuse in the last 3 of every 100 cases. And even occasional recreational cocaine users increase their risk of sudden death as a result of prone restraint. And the same risk likely pertains to methamphetamine. Well, what about this excited delirium thing? So this is a serious physiological and physical meltdown that can lead to death. The subject's behavior indicates the syndrome. Now, according to the American College of Emergency Physicians Task Force on Excited Delirium, a subject must exhibit both delirium and hallucinations, severe confusion, and acute disorientation, and an excited or agitated state for excited delirium syndrome to be basically present. And a person with excited delirium experiences an extreme fight or flight response by the nervous system and might demonstrate symptoms like unbelievable strength, or being impervious to pain, which means they don't feel it, or the ability to effectively resist multiple officers over an extended period of time. So you've got sweating and rapid breathing and bizarre and violent behavior, and paranoia and being incoherent and shouting and hallucinations and confusion. And that's kind of the essence of this thing called excited delirium. So with all of that being said, what is then reasonable? Because we're going to come back to this reasonable force thing. So what is reasonable? And what constitutes it? Well, what constitutes reasonable force was established in that case, Graham versus Connor, back in 1989. And in this case, Graham, who had diabetes, asked a friend to drive him to the store for some orange juice to counteract the insulin. And the friend agreed, but when Graham entered the store, he saw that there was a long checkout line, and concerned about the delay, he kind of hurried out of the store and asked the friend to take him somewhere else. Well, Officer Connor, seeing Graham kind of run out of the store and leave the store, got suspicious and followed them. And about a half mile later, he made an investigative stop. And although the friend told Connor that Graham was simply suffering from a sugar reaction, the officer ordered the two men to wait while he found out what, if anything, was kind of going on. And when the officer returned to his patrol car to request backup, Graham got out of the car and passed out on the curb. Now, moments later, a number of other officers arrived, and one officer rolled Graham over on the sidewalk and cuffed his hands behind his back, ignoring the friend's pleas to get Graham some sugar. And several officers then lifted Graham, carried him over to the friend's car, and placed him face down on the hood. And after regaining consciousness, Graham asked the officers to check his wallet for a diabetic decal, and things kind of happened from there. So I don't have time to kind of go through the whole thing. But that's the essence of what took place. Now, in this case, came out 4 factors against which officers' actions are going to be measured. And those 4 factors are listed here. The immediate threat of a serious physical harm to the officers or others. The degree to which the situation is tense, uncertain, and rapidly evolving. The nature of the crime at issue. Okay, maybe a man with a gun versus a petty theft or something. And whether the person or the subject or the suspect, whatever word you want to put in there, is resisting arrest by attempting to evade arrest or flight. So these are, in this Graham case, the court listed 4 factors again, okay, in which an officer's actions must be measured. So to kind of go back to Graham, if you're really wondering what the outcome was, the officers grabbed Graham when he woke up, kind of threw him headfirst on the police car, and then finally Connor received a report that Graham didn't do anything wrong at the store, and the officers drove him home and released him. And during the encounter, Graham sustained some injuries. And he also claimed to have developed some type of permanent ringing in his ear. He filed a lawsuit against the individual officers in the incident, alleging they had used excessive force in making that investigative stop. And the court ruled, however, that the officers did not use excessive force, and the explanation on that is in the case that I will let you look up and kind of read yourself. So how do we define then when we talk about excessive force? So we've kind of defined force, and we're walking in that direction. We've looked at the continuums and kind of what reasonableness means. Well, what about excessive? When does it become too much? Well, the IACP, remember, the International Association of Chiefs of Police, defines excessive force as the application of an amount and or the frequency of force greater than required to compel compliance from a willing or unwilling subject. And this is force beyond that which is reasonably necessary to accomplish a legitimate law enforcement purpose. And excessive force, of course, is synonymous with what they call police brutality. And again, not to pick on the guys, but research has found that women officers are less likely to use force than their male counterparts. So again, excessive force, that force beyond that which is reasonably necessary to accomplish a legitimate law enforcement purpose. Well, how do we then come up with ways to not use like lethal force in some situations? Well, we've developed tools over the years, and a lot of those tools that we have fall under the realm of what we call less lethal force. And this force, or is force, that has less potential for death, serious injury, than traditional tactics. So things like restraints or aerosols like pepper spray, or impact weapons like batons or tasers, things like that. Now, while those are less lethal, they can still be fatal. And therefore, again, options that are available for controlling a suspect with less lethal force would be, of course, verbal or visual management at the scene, empty hand controls, restraints, aerosols, kind of like what we talked about, impact weapons, or tasers. Those are some less lethal options that are definitely out there. And again, I think by definition what all of those different things are. Now, what about deadly force? Now, I just mentioned that sometimes less lethal can turn out to be lethal. But what about this deadly force thing? Well, any force that can reasonably be expected to cause death or serious injury. And remember, under the Fourth Amendment, taking a life is a seizure, which must be reasonable. Remember? Because we judge it under that reasonableness thing. So although definitions vary among jurisdictions, deadly force is generally defined as any force that can be reasonably expected to cause death or serious bodily injury. And the authority to use deadly force is a huge, awesome responsibility when considering the justifiable use of deadly force. Two interrelated rights are really important to remember: the legal right to use such force and the moral right compelling the officer to do that or to do so. Now, justification for use of deadly force must consider, again, the legal right and the need to apprehend the suspect compared with the arresting officer's safety and the value of human life. So what is deadly force? Any force that can be reasonably expected to cause or is intended to cause death or serious injury. And there's a landmark case out there that I think I hope I have in here. Okay, it's coming up, so I'll get to it. But there is a landmark case out there called Tennessee versus Garner. It was in 1985, and it basically bars the police from shooting to kill fleeing felons unless there is imminent danger to life. And this ruling invalidated some state laws that were passed in a lot of states at that time that allowed the police officer to use deadly force to prevent the escape of a suspected felon. But if you go back to some of the use of force things that we talk about, remember, any force that can be reasonably expected to cause or is intended to cause death or serious physical injury, and when you should be using that. Along with, under the deadly force umbrella, is this thing called contagious fire, or the phenomenon of contagious fire. And it can be defined as the phenomenon that occurs when one officer shoots, causing other officers to have what they call prolactivity to also shoot, even if they're unaware of the justification for shooting. So when one officer shoots, others shoot as well. And so again, kind of an interesting phenomenon here. And most officers find the term offensive because it is frequently misused to describe an officer-involved shooting. And when multiple officers simultaneously fire their weapons because each officer has individually perceived the threat and made the decision to use deadly force based on that perceived threat, this is not a case of that contagious fire. This is a case of the officers all perceiving a serious threat. So hopefully that kind of makes sense. And as we continue to talk about a couple of things here, on page 367 in your textbook is a summary of the law on use of force. It's at the bottom in kind of green, and you can look at that and it'll show you on the left the situation, in the middle the less than deadly force, and then on the right deadly force. and it's a pretty decent chart for you to look at to talk about things. So what about unarmed suspects? So we've kind of talked about this contagious fire, and then let's look at like unarmed subjects. Well, when police shoot unarmed people, okay, or suspects, the public is often outraged, and some question why the officer could not just shoot the subject, say, in the knee. And I know that says no, so sorry about the typo. Well, the answer to this is when an officer determines they are justified to use deadly force, they are trained to shoot to stop or end a threat, not to injure. So it's not as simple as it seems. We're not in the Western days where Annie Oakley can shoot somebody, if you even know who that is, because you're all young and I'm super old. But we're not trained to shoot someone in the hand or to shoot someone in the leg. When we pull out our firearm, that's a point where the officer has determined in their mind that they are justified to use that type of force, and they are trained to shoot to stop or to end the threat. And what happens sometimes is this thing called conditioned hesitation based on what we just talked about. Now, many factors can lead an officer hesitating in a kill zone, and such hesitation in a crisis can potentially cost the officer or somebody else their life. And the factors that impact this are things like training, or the level of physical fitness, or the mindset or attitude of the officer, or the suspect or the subject factors, and even fear. And some fear that because of all the hype going on with officer-involved shootings right now, that the officers are hesitating to use deadly force when they probably should have, and some of them are getting hurt and in fact even killed because they don't want to overstep their bounds when they were in fact justified in the first place. And some other things that fall under deadly force. And here's the case that you can take a look at of the Tennessee versus Garner case. The top link is to a case summary, and the bottom link actually is to a pretty cool video that will outline that. And we're not going to take the time to look at this case either, but if you want to, you can click on this YouTube video and apply this to the Tennessee versus Garner case. So take the time, look at this one first, and evaluate the case and watch it and learn from it, and then see how this case fits in. This video fits into that particular case. So to kind of end up, we're going to talk about some other issues. One would be avoiding use of force related problems. And how do we do that? Well, several keys can help officers better navigate the complex interplay of law, human nature, interpersonal communication, physical ability, and specific weapon proficiencies. Now, first, officers must possess solid interpersonal and emotional management techniques to help them de-escalate volatile situations and gain voluntary compliance without the need for force. And second, officers must ensure that the core transaction, whether an arrest, detention, search, or seizure, is legally valid. And third, officers must be well trained in the complex and dynamic nature of use of force scenarios so that their decision making takes into account the full range of objectively reasonable responses. And finally, officers must take care not to poison, if you will, a correct or reasonable use of force case with behavior such as like verbal abuse of the person, or name calling, or things that reflect negativity on professionalism and etc. And with that, officers do have protection and rights in use of force lawsuits, and it's under the Garrity protection. And officers must be told that they retain their constitutional rights and that any information that's provided in let's say, an internal investigation can't be used in a criminal proceeding that is brought against the officer. So the garrity protection itself is where employers can insist that an officer provide information for an administrative investigation, but the officer must be told that they retain their constitutional rights and that any information provided can't be used in a criminal proceedings if brought against the officer. So police officers involved in use of force incidents, they have constitutional rights as well. And they have some protections that again are built under this garrity protection. And then finally, we're gonna talk about police pursuits, and we're gonna go over just a little bit, but we're almost there. And this is a little bit longer of a section. So one controversial type of force used by law enforcement is the pursuit, which may not only cause significant property damage, but also can result in injury or death to fleeing suspects, pursuing officers, or even innocent bystanders. Now, data shows that between 1982 and 2013, 10,642 people were killed as a result of police pursuits, whereas 1/3 of those killed were in fact innocent bystanders. And we're going to skip, for sake of time, the second discussion question. So let's go this way. Here we go. A pursuit is defined as an active attempt by a law enforcement officer on duty in a patrol car to apprehend one or more occupants of a motor vehicle, providing the driver of such vehicle is aware of the attempt and is resisting apprehension by maintaining or increasing his or her speed, because it can be a her, or by ignoring the law enforcement officer's attempt to stop them. Now, the controversy over pursuits ranges from those who say pursuit should be banned totally to those who say pursuit should be allowed under certain circumstances, to those who say pursuit should be left alone to the discretion of the officer involved. And all departments have pursuit policies that tell you when you should initiate a pursuit and perhaps when you shouldn't, and factors that should influence that decision. So the basic dilemma of pursuits is whether the benefits of the potential apprehension really outweigh the risks that are posed. Now, the three aspects of police pursuits that are agreed upon by law enforcement agencies and kind of everybody else would be, we know that they're dangerous. They are. So that's one thing. We know that they have to be controlled. And we know that pursuits increase the participants' adrenaline and excitement, both the suspect and the officer. And there's a high probability of damage to property and people. And again, many advocate possibly discontinuing pursuits. But again, departments have pursuit policies that talk about those different variables. And on page 373 in your textbook, you'll see a section on pursuit policies, because we're not going to be able to go through them. But they actually have a management continuum that's listed here that talk about beginning the pursuit and possibly when you may want to not do a pursuit, or when you might do this, disengage, which is an option, meaning that you might start the pursuit, but at some point it gets so out of control that you're going to disengage or stop, and that this is in fact an option that is out there to you. And because so many police pursuits end in crashes and some in fatalities, a lot of lawsuits are truly inevitable. Now, departments can, however, minimize the risk of lawsuits by having good policy. And there's a case out there, County of Sacramento versus Lewis in 1998, that sets the standard for what we call liability in police pursuits. And in this case, 16-year-old Philip Lewis was the passenger on a motorcycle driven by an 18-year-old Brian Willard. And when Willard committed a traffic violation, a sheriff's deputy tried to stop the motorcycle, but the driver sped off. Now, the deputy followed, and during the pursuit, the chase reached speeds of about 100 miles an hour. And the pursuit ended when the motorcycle tipped over and Lewis was struck and killed by the patrol car. Now, the Ninth Circuit Court ruled that the deputy was liable for Lewis's death by showing deliberate indifference to or reckless disregard for the right to life and personal security. But, okay, there's good news. Hang on. The Supreme Court, however, overturned that ruling and said basically only conduct that shows an intent on the part of the officer to cause harm unrelated to the legitimate object of making the arrest will meet the test of shocking and arbitrary conduct actionable as deprivation of substantive due process. As a result of Lewis in a high-speed vehicle pursuit case, Section 1983 liability ensues only if the conduct of the officer shocks the conscience of the court. The lower standard of that deliberate indifference doesn't apply. So, yeah, liability is a legal obligation that's incurred for an injury sustained or complained about that results from a failure to conduct a specific task or activity within a given standard, and that's your policy. And that liability happens when officers, for example, violate policy. And when they do that, they get that thing called civil liberty or civil liability. And again, another thing that comes to mind is this thing called legitophobia, and that's like lawsuit paranoia or the fear of litigation. And fear of being sued can cause confusion regarding which action to take in a given situation, the kind of damned if you do and damned if you don't dilemma. An example could be, for a while, citizens in need of life-saving assistance were filing lawsuits and winning lawsuits against those who responded to help them, to aid in their rescue. And people then grew reluctant to get involved because they didn't want to get sued. Well, later we kind of fixed that, so to protect well-intended people that are coming to help, the Good Samaritan laws were passed that required a showing of gross, wanton, or willful negligence before somebody could be sued, so that kind of helped that. And then there's liability in other cases that are out there that we're not going to really have time to go through, like United States versus Ramirez, and lawsuits that are applicable to, let's say, SWAT teams, because there's a lot of liability as it results to SWAT teams. And then the Brady versus Maryland case in 1963 that talks about the duty to disclose exculpatory evidence. And so this Brady versus Maryland case places on a prosecutor a constitutional duty to disclose what they call exculpatory evidence, which means stuff that's favorable to the suspect, to a defendant and that defendant's attorney. So again, this all kind of falls underneath the umbrella of liability. Well, how do we reduce civil liability? Well, there's a couple of different ways. Through incident reports, through things like body-worn cameras, which are actually starting to kind of find their way into things like this. So when police chiefs, though, were asked what steps could prevent lawsuits, the most frequently answered, or the most frequent answer that they got, would be treating people fairly, better training, better supervision, better screening, and early identification of problem officers, in that order. Now, to help with increasing that increasing tangle of legal issues, many agencies now employ part-time or full-time legal advisors. Now, one way, of course, again, and it's up here on the slide, would be to to reduce a risk could be, to apologize. And there's good and bad to that. Thorough incident reports, making sure you're documenting everything and being very, very thorough. Or body cameras becoming increasingly popular options to agencies to better document what occurs during different incidents. And then finally, and I know we're going over, but I just kind of can't help it, and I'll try to get through this as fast as I can, would be corruption. How do we deal with that? Here's a link to the Rampart, the report, the public report on the corruption issue of Rampart in the Los Angeles Police Department. So take a look at that. Now, corruption is a violation of integrity through the abuse of one's role or position, or the influencing of a person in authority, either for personal benefit or the benefit of others. And corruption occurs when an officer misuses that authority for personal gain, including taking gratuities. And corruption, brutality, extortion, bribery, theft, rape, aggravated assault, drug trafficking, murder, excessive force, a lot of these things kind of fall in line, and they even have a kind of corruption continuum that's listed in your textbook. So again, misuse of authority for personal gain, and corruption can include all of the things that I kind of talked about. There are key elements of corrupt behavior, and there are 4 that are listed, and it's that conduct is prohibited by law or rule. Actually, there's 3. Conduct involves misuse of position, and conduct involves a reward or personal gain for the officer. Now, just as the text that we've looked at a few minutes ago, just as use of force and pursuits kind of have a continuum that you could look at to describe what's going on, there is also a continuum, if you will, that exists to describe the transition from honest cop to corrupt cop. And I'm not going to go through every single one of these because of time, but it consists of what we call the slippery slope, or the noble cause and end justifies the means, or being above the law, or bad apples, or a bad barrel. Is it one or all? Or this thing that we call the code of silence. And I'll let you take the time to kind of look at that. And here's the continuum again of compromise that shows how things kind of start at the beginning and kind of keep going. Well, how do we learn about ethics, and how do we fix some of that? Well, we learn about it through checks a lot of time, and ethics involve things like moral behavior and doing what is considered right and just, and police managers may provide ethical leadership by helping officers to develop their ethical decision-making skills. So there are some things that you can do, and one simple adage might serve as a starting point for a discussion on ethics. There is no right way to do a wrong thing, and you could ask yourself these 3 questions: is it legal? Is it balanced? And how will it make me feel about myself? And so the definition of ethics involves moral behavior, doing what is considered right and just, and the rules or standards governing the conduct of the profession. Honesty, honor, morality, allegiance, principled behavior dedicated to the mission, and things of that nature. Well, what about, again, under ethics checks, what about the importance of integrity, and is that different than ethics? Well, it is. Integrity, the most important quality a police officer can possess, is a series of concepts and beliefs that provide structure to officers' professional and personal ethics. And these concepts and beliefs include those things like honesty and honor and morality and allegiance and principled behavior and dedicated to the mission. And if you look on page 383, you can see the dynamics of police integrity. Actually, I have this kind of right in front of you. So building an ethical department, and then we're going to be done. You can do it through a bunch of different ways, and one would be the application or selection process, making sure that you are picking only the right folks, and consistent reinforcement of values through training and professionalization, and an anti-corruption posture of checks and balances in your department, good policy and leadership, and also internal investigations, making sure that you have a good group of investigators that help you with those checks and balances when it comes to internal affairs investigations. So I know that was a lot, and we ran way over, but again, go through your textbook and read to add context to the discussion that we've had, because there is so much information there. And don't forget about the key terms at the beginning of the chapter and the discussion questions at the end. So with that being said, until next time.